which are extracted in an under the 40%. यहाँ से additional affidavit के page 11.
Just one word, read with annexure A3. There also, since 2014, it was clarified that it will not be seniority and only merit. Annexure A3. Page 15,
Also, circular dated 6 February 2014.
I know.
Annexure A3, page 15. The additional affidavit. It's argued that the selection process had to be based on merit and not seniority,
I don't know.
as was so erroneously inserted in the which condition was erroneously inserted in the advertisement dated 8 February 2022, recognize the video of the main question. So, realizing the mistake, the authorities took action took remedial measures by issuing communication dated 2nd of August 2022, page 47.
Yes,
book. And as such, the advertisement stood withdrawn. Notice and we'll still let it stay. We'll stay.
Stay, there's a consent. I'm obliged to this. Leave your fault. Item 49.
The paper did please. Yes.
Good. Yeah, just take you.
Yeah, Mr. Anderson, just for the information of all the members of the bar, we take up this matter first. Should this matter collapse, then only we take up the other matters which I discussed before. Otherwise, this matter would continue. Yes.
Great. Now, sorry.
Mr. Devan,
Yeah.
Subramaniam, both of you. First, not that we are not noticing the others. One proposition of law which the courts, I court has held that it's a fundamental right. Now, on that, can you assist us first?
I'm speaking for myself, Lord. I don't think we need to even pitch it that way because.
No, but that is what the High Court has held.
Lord, if I may say so, the thrust of the judgment is that there is a rule which is an enforceable rule, and therefore there is a binding legal obligation to equate the dearness allowance payable by the state government with that of its central government. So it is not founded on a rule. And there is, of course, Lord, an observation in relation to discrimination. And in that context, Lord, there is an allusion to fundamental.
We only thought that.
Yes, it's not a pan-India. Lord, I realized it when your lordship spoke. And this is not trying to be a pan-India. In fact, Lord, there are many states which adopt the same dearness allowance patterns that of the central government because it is based on a price index. So that's why
just a passing observation. It's not whole.
It's not the heart of the judgment.
In fact, the first judgment which really relies upon the enforcement of the statutory rules. not real fundamental right.
My lords, if I may address on that point, because our submissions are slightly different. We have written, as my lords had asked, all the written submissions, say Mr. Bhattacharya, we received those, and those will be submitted when we begin arguments. They're photocopying now because we received some half an hour. My lords, in that, it is quite clear that with regard to this SLP, the legal right is necessary and sufficient. The fundamental right only comes in if we are looking at the next FROPA rules of 2019. Otherwise, for this SLP, with regard to the 2009 rights, legal rights are necessary and sufficient.
See, why we are saying so?
Yes.
Let's get
We, as we read the judgment, and little bit knowledge that we had, and research we could do, we could not find any proposition thus far, subject to correction.
No, but it's not the decision of court, it's a fundamental right. As mere observation, I shall place it not. The
One
first
judgment
judgment,
allow us to.
Sorry.
Oh,
sorry, well, I could really follow.
we are only saying that it is this what really was we were really looking for, because it can be said that it's a fundamental right. It's something which was we were pondering, we were working on, but we could not find any material on this, so we thought that maybe this.
Okay, so Manoj, let me just place it. So,
My
may-
lords,
may I-
let me just answer.
May I just answer?
Yeah, let them answer. No, let them answer.
May I just say
They also learn.
May I
Not
just-
their argument, this to be fair, is an argument because it had fallen from my lords.
No, it has not fallen from us, it has fallen from,
It's fallen from the High Court. It's fallen from the High Court, that's
we are not saying.
So we have addressed that as a subsidiary argument. The crux is the legal right.
So therefore, both sides would say it is not a fundamental right. That's
not for the
No, but we'll
purpose
assist
of
you on
the
it
question,
as
for
we
the
can.
purpose of your lordship's question, the position under the constitution would be that a government servant is necessarily controlled by rules which are framed under the proviso to Article 309. And there are rules which regulate pay. So pay, is necessarily a matter which is governed by the rules. So if a rule is arbitrary, that's a different point altogether. But to make a claim for dearness allowance as if it was a fundamental right, I think may not be.
Thank you very much.
That was not our contention also before the High Court. Our contention was enforceable right.
Thank you very much. That's what we were really looking for. We were concerned about. Yes, Mr. Dugan.
Okay. So Manoj, may I-
Okay.
So may I first invite your attention to page 21, paragraph 23.
Yes.
As the pleadings indicate, it stands undisputed that due to erosion of the value of salary of government employees and non-payment of DNS allowances long, to neutralize the erosion, sustaining livelihood of government employees has been affected to a great extent, as revealed in the report of the Fifth Pay Commission. As held above, to get DNS allowance at the rate to be calculated in terms of the All India Consumer Price Index average is now the legally enforceable right of state government employees. What we feel, apart from acquiring an enforceable legal right to get DNS allowance using the methodology of the All India Consumer Price Index, such right of employees to sustain their livelihood with human dignity has been fructified or elevated as a fundamental right as enshrined in Article 21 of the Constitution. Such right available to government employees are the main workforce behind the functioning of the government in right direction cannot be denied by the state. As observed by the Pay Commission, we are of the same view that to pay respect to the statutory rights of the government employees to get DA allowance at the rate as above, the government must generate all its resources. We feel that denial or deprivation of the legitimate claim of DNS allowance of the employees to sustain their livelihood in a dignified manner may have a demoralizing effect upon them and may in turn adversely affect the smooth functioning of government. In such backdrop, the stand taken by the state that due to financial inability is not in a position to pay DNS allowance to its employees at the rate of calculated with the methodology of a uniform All India Consumer Price Average is not acceptable. while the claim of the employees to DNS allowance is backed by statutory and fundamental rights, and the court finds that the state turns deaf ears to such rights, the court, in exercise of its extraordinary judicial power, may direct the state to implement such rights of employees. So I'm just placing this part of the discussion. Now just have a look at two decisions, please. We have a compilation which I'll just place over to the court and over to the court. So the first decision which I'm citing in the give it to the other side, which I'm citing is it's cited as 1954 1 SEC 970, and it's corresponding to AIR 54 Supreme Court 493. You will find it at serial number 6 on the index which we have just handed over.
Yes, please.
State of Madhya Pradesh versus GC. Your Lordship has it?
Yes.
Yes. So, where was the opening paragraph first? The point for decision in this appeal is whether the resolution of the government of the central provinces and Virar, now Madhya Pradesh, dated 16 September 1948, fixing a scale of DNS allowance to be paid to its servants, is repugnant to Article 14 of the Constitution. The circumstances under which the above resolution came to be adopted may be briefly mentioned. Consequent to the war, there was a phenomenal rise in the price of foodstuffs and of other essential commodities, and among the persons worst hit by it were government servants. As a measure of relief to them, the central and provincial governments sanctioned a grant of grain allowances to them under various resolutions passed in 1940. The scheme adopted by the central government was that its employees stationed in various provinces received the same benefit as the respective provincial government employees. But the scheme was found to be unsuitable for the employees of the central government, as the allowances granted by the provincial government were not uniform. On 10th May 1946, the central government appointed a Central Pay Commission, hereinafter referred to as the Commission, to inquire into and report on the conditions of service of its employees, with particular reference to the structure of their pay scales and standard remuneration, with the object of achieving a rationalization, simplification, and uniformity to the fullest degree possible. The commission, which was presided over by Sir S. Vardacharya, recommended by its report dated 3rd May 1947 the grant of DNS allowance on a specified scale. On 27th May 1947, the government of the central provinces and Virar appointed a pay committee, hereinafter referred to as the committee, to examine the recommendation of the Central Pay Commission and to report to the extent to which and the modifications subject to which these recommendations should be accepted by the provincial government, so far as the government servants under the rule-making power of control are concerned. By its report of 22nd June 1948, the committee recommended the grant of DNS allowance on a scale which, though practically identical to that adopted by the Commission in respect of salaries over rupees 400 per mention, was less than as regards salaries of rupees 400 per mention or less. These recommendations were accepted by the government by its resolution of 16 September 48. This difference in the result between the two scales not unnaturally caused considerable dissatisfaction amongst the employees concerned, and after unsuccessful attempts to get redress on the executive side, they filed through the representative, the respondent, the present application under Article 226. Now please go directly to paragraph 5 on page 125. On the first question, Rule 44 of the fundamental rules runs as follows. Subject to any restriction which the Secretary of State in Council may, by order, impose upon the powers of the Governor General in Council or the Governor General in Council, as the case may be, and to the general rule that the amount of a compensatory allowance should be regulated, that the allowance is not the whole source of profit to the recipient, a local government may grant such allowance to any government servant under its control and may make rules prescribing their amount and the conditions under which they may be drawn. Under this provision, it is a matter of discretion with the local government whether it will grant DNS allowance, and if so, how much. That being so, the prayer for mandamus is clearly misconceived, as that would be granted only when there is in the applicant a right to compel the performance of some duty cast on the opponent. Rule 44 of the fundamental rules confers no right on the government servants to the grant of DNS allowance. It imposes no duty on the states to grant it. It merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus can issue to compel the exercise of such power, nor indeed could any other writ or direction be issued in respect of it, as there is no right in the applicant which is capable of being protected or enforced. So we would draw on this particular observation in support of our submission that there is no fundamental right. Now there is one more decision which may be of assistance, which is at page 129 of this paper book. So this is Videsh Sanchar Nigam Limited versus Ajit Kumar, 2008 11 SEC, page 591. And may I request you to go to paragraph 51 at page 147.
Paragraph
51.
Yes.
What is the order? So DR is DNS relief, para 51. It is well settled that DNS relief is a matter of grace to the government servants and not a vested right, and hence a claim against the government for the grant of such allowance at a particular rate is not justiciable. The grant of DNS relief at such and subject to such conditions is the prerogative of the central government in terms of Rule 55A of the CCA Pension Rules 1972. Rule 44 of the Fundamental Rules for the grant of DNS allowance imposed no duty on the state to grant it, and it merely confers a power on the state to grant compassionate allowance at its own discretion, and no mandamus or any other writ or direction, therefore, could be issued to compel the exercise of such a power, as there is no right in the employees which is capable of being protected or enforced. So this is, of course, as your lordships have noticed, a judgment rendered by a panel of 2 learned judges, the 2008 judgment, but it draws on, as the court has seen, the state of Madhya Pradesh judgment versus Mandawar, which is a constitutional bench judgment dating back to 1954. So we believe we would commend this approach to the court, which is to say that there is no right as such. It's a matter of discretion, and therefore a mandamus doesn't lie. Because there's no public duty or there's no duty in terms of the rule. So that's going to be the broad framework as far as our submissions are concerned as well. Now, this was our effort to answer some part of your lordship's question. Now, may I just go through the first and foremost?
We are in fact, to be honest, we are relieved. Both sides are not taking this plea that it is a fundamental right. We have doubts about this finding at page 21 of the High Court.
Yeah, I think that's a fair assessment, judging from what they said. Yeah, and what we say. But I think we are also buttressed by this authority, which your lordship will consider in the correct perspective. But we feel that this seems to be the settled law, that this is a matter, it's obviously a matter of discretion as far as the state. That's an important prism to examine this entire case under. Because I want to now take your lordships to what they sought and what was granted by the tribunal, which has been sustained. I'm very grateful. Now, there are, the petition is on record, but the application rather before the tribunal is on record. But it's not typed very accurately. So may I just request you to go to page 268 of the paper book, volume 1. So I'm first taking your lordships to the prayers, which I think are reproduced accurately here.
266 of the
of the two, yes, it begins at 268. It's a copy
268.
of an order. Volume 1, Manoj.
This is the prayer before the tribunal.
Yes, it's elsewhere as well, but the typing is not very accurate. So I'm just reading it from this was the application.
268.
yes.
May I place it? The application has been filed by two organizations of the West Bengal state government employees seeking the following amongst other relief. A direction upon the respondent authorities to forthwith release the 50% DNS allowance, which is due up to January 2006. This is a typing error. It should be 2016.
Yes.
Immediately within a period of 1 month from the date of receiving of the order. So this is one part which they asked for.
Yes.
B, a direction upon respondent authorities to immediately comply with the report of the recommendations of the 5th Pay Commission report positively and without fail within a period of 1 month from the communication of the order. C, a direction upon the respondent authorities to release the 50% of DNS allowance as the state government, without releasing the 50% DNS allowance for mere eyewash, set up the 5th Pay Commission, who recommended for 10% interim relief upon the basic pay, but no whisper about due 50% DNS allowance. And unless the court intervene into it, there may be every possibility of forfeiture of that 50% due DNS allowance, which is the penultimate goal and gain of the state government, and the applicants will suffer irreparable loss and injury. And D, the applicants pray for relief order directing the respondent authorities to grant 50% of the DNS allowance as that of the central. Now, this was the framework of the prayers which they saw. So, I want to just mention a couple of things. You will notice, one, there is no challenge to any rule which is extant. Number two, there is no challenge to any memorandum at all, which has been issued by the state government, explaining the scope and the amplitude. So these are two things which your lordship may just at this preliminary stage know. Now may I request the court to go to the tribunal's decision, where I want to place just a few paragraphs and then the operative directions. That you will find at page 462. Yeah, second volume.
Volume 2.
Yes, it's volume 2. It's annexure B20.
Page
462.
It's a judgment of the tribunal.
Yes, which was eventually assailed before the High Court and sustained by the High Court.
Just one.
Yes.
Part 2.
Yes.
Yes, please.
The lordship said page 462.
Yes.
Yeah. May I jump to page 476?
Yes.
I wish to place para 25. The lordship has, sorry.
Yes.
Para 25. Now we would like to consider the first issue, namely whether the employees of the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government.
Just.
Sorry.
Yes. Yes.
So I'm just placing the question para 25, which they thereafter proceed to answer. Page 476. Now we would like to consider the first issue, namely whether the employees of the government of West Bengal are entitled to get DA at a rate payable to the employees of the central government. Your Lordships have that.
Yes.
Correct? Then, my Lords, with your permission, I'm skipping the some part of that discussion. Please go over to page 476.
Yes.
And about 10th line from the top, you will find there is 10th line, there is no mandate.
There is no mandate.
Yeah, so I'll just emphasize that. There is no mandate either in the statutory rules framed by the state government or in the administrative directions issued by the state government as to how DNS allowance will be released by the state government for its employees from time to time, whereas the central government has specifically accepted the recommendations of the Sixth Pay Commission for release of DA to its employees twice a year, as on 1st January and 1st July, payable with the salary of March and September respectively for administrative convenience, with inflation neutralization being maintained at 100% at all levels. However, what is explicit from Rule 31E, these are our rules, 31E of, okay, it should be 31C of the ROPA Rules 2009, is that the state government has adopted the index with a base year of 1982 as the basis for determination of revised pay structure in terms of the 2009 rules by following an index as on 1st January 2006. It's also pertinent to point out what is implicit in Rule 31C, read with Rule 7 of the ROPA Rules 2009, along with paragraph 10 of the Memorandum of 23rd February 2009 and Memorandum of 23rd February 2009, is that the state government has followed the pattern of the central government in payment of DA to its employees at the same rate, but from different date, at least till 2010. Now let's go to the table, which is part of the impugned order on page 478. Page 478. Your Lordship has a table there.
Yes.
Correct. Now just see, I'll just explain, at least my understanding of this table. So I'll place the table, see the heading of the left-hand first column. GO number of Finance Department, Government of West Bengal. All right. So this is how they've tabulated. Then the rate of DNS allowance released by the state government. Okay. So the rate is 2%, 6%, 9%, etc. We'll come to that. Date of effect given by the state government. So the starting point is indicated 1st April 2008, 1st June 2008. Then rate of DNS allowance percentage released by the central government. Your Lordship has that. And here you will find that at least insofar as the tribunal sets out, all the way up to 23rd November 2010, you will find that the rates are generally the same.
Same more.
Yeah. However, the start point for the central government is the extreme right-hand column. So just have a look at that. Date of effect given by the central government. So do you have, for example, 1st July 2006 over there? Your Lordship has that. So just see as far as West Bengal government is concerned, it was 1st April 2008. Right, same rate, but there's a slight slack. I'm just mentioning it. This is just an analysis by the tribunal itself. Then the tribunal after 2012 doesn't set out as to what the central government rates are. It doesn't, because it mentions it on that earlier page where it says that there was a consistency. But what I want to point out on the right-hand column is please see the steady increase, because eventually our submission is going to be A, there is no fundamental right. B, there is no legal or statutory right. C, it's a matter of discretion on the part of the state, which of course, like all discretion, has to be exercised in a reasonable manner under our system of governance on the basis of relevant factors. One of the relevant factors is going to be fiscal availability of funds, priorities, because of the whole matrix of circumstances which have to be looked into. But the first thing which will strike you when you see the left-hand column is that it's not as if the state government is in repose. As far as DA is concerned, even after 35, it goes up to 45, 52, 58, 65, 75, 85, 100, 125, etc. And this has been paid. Please note that. This is in terms of our rules. This is in terms of exercise of discretion. So it's not a case where DA is not being paid. It is being paid. We'll give you those figures, etc. It is being calibrated upwards. But having regard to our abilities and our decision making broadly, and this in our respectful submission, this whole claim of parity, which you will find when I go to the next few paragraphs, has been expressly rejected by the tribunal. And after expressly rejecting it, I should qualify that. On my reading, they have expressly rejected it. But even after expressly rejecting it, they have brought it back in a sort of by a side door, which I don't believe is sustainable at all, which is why we went to the High Court. And of course, the High Court, as you know, has sustained it. So this table is of great value, particularly because it shows that there has been a periodic increase of DA even by the state government. And this we believe, of course, if someone comes forward to the tribunal and says that, look, this is what has been notified, but it is being denied to me, then I would respectfully submit that person has a right and the government has a corresponding duty to pay this amount. But that is the extent and scope of rights, and that's the extent to which the tribunal can go. It cannot and ought not to have done as it has over here, which is to bring in a backdoor method of parity, which is, according to us at least, not quite right. Now, yes, please.
1 minute first. I don't want to interfere in this. Just kindly come to the 7th schedule of the Constitution. I'm sorry. Kindly come to the 7th schedule. Then kindly come to entry 41 of list 2.
State Public Services,
That's
State Public Service Commission.
State public services are exclusively in the control of the state. All salaries, all allowance. So the DNL's allowance is to be decided by the state because it relates to the public service of the employees of the state. And therefore, each state has a different method. There are 13 states which don't follow the central government method.
I don't think so. We have any doubt about this proposition.
Therefore, the central government will never apply to us because that's our domain under some state public service.
Subject to what they say, and subject to correction, I don't think so. We have any doubt about it.
If you don't follow, then the order says that you have to.
Will be.
I'm just pointing out there's a constitutional issue. That's all. I'm sorry.
No. Yeah.
Just one.
Yes. So your lordships have now seen the table and the progressive increase over a period of time.
Yes.
That's at page 478. Now please go directly, still part of the order which was challenged before the High Court, 484 please, 484.
Yes.
Now, Manoj, I'm going to just read from here till this. Let me place para 33, please. We have already observed that there is no mandate either under the statutory rules, which is ROPA. Because ROPA is short for Revision of Pay and Allowance Rules. So, ROPA 2009 or in the administrative directions issued by the state government in the form of Memorandum of 23rd February 2009 and the second Memorandum of 23rd February 2009, and that the DA will be paid to the employees of the state government at a rate from the date as paid by the central government to its employees. So, Manoj, I want to emphasize this. At least my reading of this is that they observe that there is no mandate. No mandate. At least that's how we read it. Now, let's see the next sentence. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at the rate payable to its employees by the central government. So I think this is also fairly clear, Manoj, at least. But what we will show you is that despite this clarity of thought here, it becomes completely woolly-headed when we go to the operative directions. But we'll come to that. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking base year 1982. Now, where is this from? May I continue after?
5 minutes.
Yes.
If you don't mind.
No.
Yes, please.
So, Manoj, may I request you to move to
Where is
page
this
480
bill? Okay.
484.
We just only wanted to remind and tell him that he has to ensure compliance of our interim order. Only he can get it
Yeah,
done.
okay.
Just tell him. Please proceed.
Sorry, I was on page 484, paragraph 33.
Yes.
And Manoj, I read the first two sentences of that paragraph to be in my favor, in the sense that it rejects the notion that whether there is a mandate for the purposes of parity between state government and central government. Now, Manoj, I'm reading on. I'm reading from the fifth line on para 33. In the absence of any mandate under the statutory rules or the administrative directions, we are unable to hold that the state government employees are entitled to get DA at a rate payable to employees by the central government. So that's clearly, I would understand, in our favor. However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rate to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of the ROPA Rules 2009 till the date of giving effect to the recommendations. Now it talks of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal.
Can you read this again?
Yes, I'll read it again, but I also need to follow what they're trying to say. So, Manoj, may I start with the word however? However, from the discussion made by us herein above, we can hold without hesitation that the state government employees are entitled to get DA on the basic pay at the rates to be calculated on the basis of AICPI number published from time to time by taking the base year 1982. It is the bounden duty of the state government to evolve norms and principles for payment of DA to its employees by calculating the same on the basis of AICPI on the basic pay fixed in terms of ROPA Rules 2009 till the date of giving effect to the recommendation of the 6th Pay Commission set up by the government of West Bengal. The state government is also duty bound to pay arrears of DA to its employees after fixing the rate on the basis of AICPI number before implementation of the report of the 6th Pay Commission set up by the government of West Bengal. We would like to observe that the state government has the discretion to make payment of arrears of DA to its employees and fund with suitable restrictions on withdrawal of the same within the specified period of time. The first issue, whether the employees of the state government are entitled to get DA at the rate payable to its employees by the central government, is decided accordingly. So now, Manoj, let me just make an effort to try and unpack this or unravel this, or what my understanding of it is. What they say in categoric terms is, one, you are not entitled. Really, that's my reading of it. There is no equivalence between state government and central government. That's the first part of paragraph 33. Categoric. There is no such mandate. There is no such obligation at all as far as the parity is concerned. Because that's the question which he had framed, you remember, when the tribunal had framed, and which they are endeavoring to answer. Then they say, however, and they bring in some notion after however, to say that it's the bounden duty of the state government to evolve norms and principles. Please see this. To evolve norms and principles for payment of DA to its employees by calculating the same, and then they make a suggestion as to how DA is to be calculated. Now, this is entirely outside the province of the tribunal, completely outside. This is entirely within the state government's province as to decide how to calculate DA, how much to give, and the methodology. Because I can understand that if there is some arbitrary methodology which is prescribed under the rules of the memorandum, someone has to challenge that. Challenge it squarely, get it struck down, and then of course the state government may have to, if it fails to sustain the methodology which it is adopting, it may have to come up with something new. But when you have an extant rule which is not challenged and which is not struck down, when you have an extant set of government memoranda from time to time, revising it, and you saw those rates going up, you have it, there is an application of mind. None of those are struck down. None of them are even challenged. We are paying in accordance with them. But then to foist through this backdoor method, whatever it means, by saying you must evolve some norms and you must evolve some principles, and you must thereafter, if there are arrears on the basis of those evolved norms and principles, pay the arrears as well. But we give you some flexibility as to how those arrears are to be paid, whether in cash or some credit to the Provident Fund. So this is at least my understanding of this. We'll come back to this because it returns in the operative directions. Now please go to page 488. So here I'm going to just in a sweep read paras 37 and 38, and then I'll come and I'll make my comments.
Please.
Para 37, page 488. This is the concluding portion. While remitting the case back to the tribunal, the division bench, this was the earlier round where we had succeeded, the division bench of the High Court has emphatically decided that the state government